penalty has been a controversial topic in the West for quite some time, especially in the United States, which remains the only Western industrialized nation to routinely put people to death. However, concerning the United States of America, the death penalty is an acceptable form of punishment, where applicable, based on legal and moral evidence that counters key arguments against its use. This deadly form of discipline has been a part of America's recorded history since 1608, with more than 16,000 people having been put to death at the hands of the state. With time, methods of execution have evolved to suit the changing times and social standards. Although not legal in every state, the current federally acceptable methods of execution are firing squad, hanging, lethal gas, electrocution, and lethal injection. No matter the method, the result is still the same: death. Legal disputations have arisen pertaining as to whether or not capital punishment is in direct violation of the Eighth Amendment, which protects individuals from cruel and unusual punishment at the hands of the government. Unfortunately, the authors failed to define what constitutes as cruel and unusual punishment. Desmond Manderson states that law is the collective expression of our belief in the human capacity for responsible action. It defines, authorizes, and enforces responsible conduct. The law's responsibility is nowhere more profound than in relation to death, a duty from which none can relieve it. The legal system is therefore ultimately responsible for ensuring that the death penalty is in no way a constitutional violation. Now, in modern America, murder is the main legal crime deemed worthy of execution. Even though the Supreme Court recognizes intentional killing as a crime to warrant the death penalty, it most certainly takes the Eighth Amendment into account when handing out verdicts. Two actual court examples of this are Atkins v. Virginia, where the Supreme Court ruled that it is cruel and unusual to sentence mentally challenged murderers to death. The second example is Roper v. Simmons, where the Supreme Court ruled that it is cruel and unusual to sentence murderers to death who are below the age of 18. And ultimately, in 1976, the Supreme Court ruled that capital punishment is not unto itself cruel and unusual, as long as it is applied within a certain set of objective criteria that allows for the consideration of the defendant's character and record. According to modern law, capital punishment is not a violation of the Eighth Amendment. Next comes the debate over whether or not execution methods are actually humane enough to be constitutional. While a case may be made against certain forms of execution, such as hanging, little can be said against lethal injection, which shuts down the central nervous system, paralyzes the lungs, and finally stops the heart, a procedure for which the subject is unconscious for almost the entirety of its duration. Humanitarian groups have cried foul over a very small number of botched executions via lethal injection, but the Supreme Court ruled in Bays v. Rees that lethal injection cannot be considered a cruel and unusual punishment because not enough evidence exists regarding the infliction of pain to prove otherwise. Therefore, at least one form of humane execution exists, as deemed by the Supreme Court. The misinterpreted theory of retribution is often used as a moral argument against capital punishment, even though it was and still is evidence for capital punishment. Retribution may be defined as the rationally supported theory that a criminal deserves punishment fitting the gravity of his crime. Many inaccurately see this as unnecessary vengeance, but the problem with this generalization is that the rationalization behind legal punishment is that the accused should be given what he deserves. Many would argue that murder should be treated like rape, for instance, where the murderer does not have his own crime committed against him, or the criminal does not have his crime committed against him. Murder, however, is so extremely different from any other crime, in that it is the only crime capable of permanently robbing an individual of his unalienable rights, that among these are life, liberty, and the pursuit of happiness. This is what sets intentional killing apart from all other crimes, making it deserving of death, and therefore negating the argument that the death penalty is not a morally necessary form of recompense. Murder is a very serious crime that is deserving of an equally grave punishment. Capital punishment has been used as an effective form of punishment for murder throughout much of America's recorded history. In regards to the legal and moral arguments and evidence discussed in this speech, there is no justifiable reason to not use capital punishment as the primary means of delivering justice in regards to murder.